Ready?
Yep.
First, we come to the agreement with defendant's contention that county court, having suppressed the lineup identification as the product of the illegal detention, erred in denying his motion to preclude the victim from making an in-court identification. The victim's testimony at the suppression hearing provided clear and convincing evidence to establish that he had an unobstructed and eye-to-eye view of defendant for several minutes in the well-lit kitchen, during which his attention was continuously and exclusively focused on defendant, amply supporting the court's determination that the victim's in-court identification had an independent source, untainted by police procedures. Further, in the hours after the crime, while not making a positive identification, the victim had selected defendant's photo, taken the day of the crime, as the one which looked like the assailant, requesting to see his whole body in person to be sure, and indicating that he knew he could identify him if he saw him in person. The subsequent lineup was not tainted by suggestiveness, but rather was suppressed as the product of an illegal detention. Defendant's reliance upon the discrepancy between the victim's initial estimation of his assailant's height and weight and defendant's actual measurements is improperly premised upon trial evidence, and in any event does not determine the court's independent source determination. Next, we reject defendant's claim that county court erred in denying suppression of his clothes. The issue is whether the exclusionary rule applies and requires suppression of this physical evidence as the product of illegal police activity, i.e., the illegal detention as defendant contends, or whether one of the general exceptions to the exclusionary rule applies, namely attenuation. To begin with, we agree with county court's ruling that after excising the tainted information relied upon in obtaining the warrant, the suppressed lineup identification, the search warrant used to seize defendant's clothing was nevertheless supported by sufficient untainted information acquired prior to the illegal detention to provide reasonable cause for its issuance. That is, the search warrant was based upon such properly obtained evidence as the victim's June 18, 2001 deposition describing the incident, the assailant, his vehicle and license plate, as well as the affidavit of a state trooper documenting the circumstances of defendant's apprehension, i.e. driving the automobile described by the victim, registered in defendant's name and wearing clothing and having the appearance described by the victim, and defendant's admission that he was the only one who drove the car that day and had no alibi at the time of the shooting. Finding the search warrant valid, we turn to the question of whether the physical evidence seized pursuant to that search warrant is rendered inadmissible on the ground that its production was causally related to illegal police conduct, i.e., whether seizing it during the illegal detention compels the conclusion that the inevitable evidence was come at by exploitation of that illegality, requiring its suppression as poisoned fruit. In denying the suppression, county court relied upon the traditional attenuation exception to the exclusionary rule, which we find inapplicable. That exception focuses on the presence of or absence of free will or voluntariness regarding a defendant's or a witness's statements, consent or acts which follow illegal police conduct. Thus, the attenuation inquiry resolves itself into whether the causal relationship between the police misconduct and the later discovery of the challenged evidence is so how's that?
Very good.
135.